Jane, can you turn that camera on? Oh, just my computer.
Good morning. My name is Ed David, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced. We have additional agendas, including the consent agenda, available in the back of the room and online. The consent agenda is a list of cases in which no written arguments were made to the commission in the allotted time. The commission will vote on those cases that may not be considered further today. The remaining cases on the agenda are coming before the commission to determine that reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called on the accepted agenda. As I call each case, the party who submitted a written argument will be brought to the podium to provide the most relevant arguments. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual errors, two relevant omissions from the reported facts submitted during the investigation, or three relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I'll ask that you introduce yourself as you are called upon to present your side of the case. We'll start with the business meeting and with the agenda, which will be the adoption of the agenda and the consent agenda. Do I hear a motion? Are there any amendments?
There are no amendments.
Do I hear a motion to that effect? So moved. All in favor? Second. All in favor? And we adopt the agenda. I think that the minutes were missing.
Yes. So that was my error. I did not upload the minutes for you because I wasn't at January meeting. Just put my mind. So I will have them for you for the March meeting. We'll have January and February minutes to and make
All right, so the business meeting starts with the director's report on administration.
Great. So no changes to personnel since the last meeting. For compliance, we have a memo from Jane. We have 3 cases of inactive conciliation, 5 unsuccessful and 1 successful. And you will have seen the memos to dismiss H24 0110 ABC, 1 which is 3 others, and I cannot remember off the top of my head. Can I get a motion to accept that? So Right, and our remote participation policy, the commissioners are doing this anyway, because we've been doing it by habit now for so long, but our remote participation policy requires that the commissioners indicate their votes both visually and audibly. So if you vote yes, you're in agreement with dismissing that case. Commissioner David,
Yes.
Commissioner O'Brien, yes, Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
Commissioner Sanders, yes. And then I also need a motion to approve the agreement in E 23-0282A. So moved. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David,
Yes.
Commissioner O'Brien, yes, Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
yes.
Do we have, do we have, I know we had a compliance manager, Jill, right?
Yes.
But have we had them? I thought a compliance manager.
Yeah.
But
That's old, and at some point we will get around to amending. There are a couple of forms that still list the compliance manager. At this point, mostly it's Jane for purposes of the conciliation. Barbara has taken over some of that. Michael has taken over some of that, and all of those duties sort of got split. We haven't actually had a compliance manager for like a decade. And if you remember last session, we moved Barbara's position into a major policy influencing at the legislature. And we removed the compliance manager as a major policy influencing, just don't have that anymore.
Did you attribute any particular reason for the higher number of conciliations that they held? It seemed to, or is that just the normal
Sometimes that's just the way it goes, I think.
way it goes? Okay.
And you'll see on that memo too, that there's one where the respondent has declined, but we can't send out the failed letter until the 90 days have expired, so that will be on.
Yeah, okay.
I mean, yeah. For new charges, we had 88 and with 111 respondents. The reason some of these numbers are so high is because this is for both December and January. So 23 administrative dismissals, 17 right to sue letters. For predetermination settlements, I apologize. I uploaded the wrong version of that. I have uploaded the correct one. So if you're looking at it in Drive right now, you'll see the right numbers. We had 20. 23 administrative dismissals, 17 right to sues, 24 cases that settled in some way. So 7 of them settled during investigation, 2 settled in mediation, and 11 settled privately for a total of $976,000 to the complainants. And we had 2 withdrawals with no prejudice. For training and outreach, I'm just going to move into the quarterly report. So I'm going to start with pending inventory of a total of 740 cases pending currently, with an average case age of 303 days. 257 cases in processing. They've been in processing for an average of 140 days. Processing means that they are still in the process of receiving the initial pleadings. So we've gotten a complaint and we're either waiting for the respondent's answer or we're waiting for the complainant's reply.
And those times are pretty average.
Yeah, they're a little longer right now because I was out for so long after Christmas.
Okay.
So a lot of that, there are more cases in processing than there usually are because I'm usually reviewing those cases. 234 cases in investigation with an average of 179 days since they were assigned. So some of those numbers, like I said, are a little bit higher than they were the last time, but we're still, our average case age is under a year, which is pretty good. That's what we're aiming for. And 740 cases pending that's about average for us. Staff attended or presented at 15 training and outreach events over the quarter. We are finally, I think, getting caught up on our quarter. So that was the quarter that ended in December. And if you have questions about the finance report that Michael gave you, please ask
I will ask Mike.
Michael and Julia.
What to be Michael?
We have not received any money from HUD. So that is of concern. We do have enough extra money in the HUD account to last us for some time, so we don't need to be concerned today. We will easily get through this fiscal period and next fiscal period with those reserves. But at some time we will need to worry about that.
And do we get, and I know I should know this, but do we get per case? Per case, or is it an allocated amount?
It's, yeah, so it's a little bit of both. We get paid a certain amount per case by HUD depending on how the case resolved. So if the complainant withdraws before the investigation is over, we get, I think, like $1,600. If the case goes through investigation and to a hearing here, we get $3,600. And then if we file in court, if it goes through conciliation and conciliation is not successful, then we get an extra $8,000 when we file in court. And there's some amount if they accept the conciliation as like substantial enough. I guess like $800, something like that. I can't remember off the top of my head.
Yeah. So you submit.
But then, so we submit at the end of the fiscal year, we submit a list of all the cases and how they closed, and they have been keeping track of that also because we upload things to their database. So if they agree with us, our case numbers agree, then they pay us a lump sum that is the total of how much they were going to pay us per case.
Mm-hmm.
And then they also give us a certain amount of money based on the number of cases that we processed in a year. They give us a certain amount of money for administrative costs and for training.
Per case or the end of the year?
So everything happens at the end of the year.
So it's still in limbo.
It is still in
We don't know.
We send in all of our.
Recognize made in the state.
I don't think anybody across the country that.
No, nobody has been paid. None of the agencies that do this have been paid.
That's important to know, but it's also
someone does
concerning.
that. Everybody is in the same boat. Everybody's talking to each other. Everybody's trying to talk to HUD, and not getting much of an answer back. No real plan at this point except waiting to see what happens. Like Michael said, we are in a fairly good position on that front, and that's just luck. Right now we have 4 positions that are funded by HUD money. 3 of them are only funded partially by HUD funds. 1 of them is funded 100% by HUD funds. 2 of those positions, including the one that's fully funded by HUD, are vacant. And so the reason we're in this good position is because I'm just not filling those positions. We're so far fine on staffing and ability to keep up with the caseload. I have asked in the budget to move 2 of our positions that are funded by EEOC funds into the general fund. So we can use some of the EEOC funds to cover at least one of the HUD funded positions. I asked for that because at that point we thought we were going to get HUD money and that we might not get EEOC money. So at this point, it's a smaller ask anyway, the amount of EEOC funds. So I'm just going to ask for that and then we'll move stuff around if it gets through. Otherwise, we'll put it in the biennial budget for next year.
Even though the funding is designated, that they fund a position, HUD does. We don't assign our investigators to those topics. All our investigators here are assigned all types of cases, right?
We have 1 investigator who doesn't do housing cases, but otherwise, yeah, everybody does all the same.
Okay.
And we just sort of make an average based on caseload.
Mm-hmm.
We can see how many housing cases we close in a year, and so we just make a sort of an average full-time equivalency based on those numbers. That was sort of my new business. It's just the budget at some point is going to get a hearing, hopefully not while I'm away for 2 weeks, but Michael and Barbara will cover it if I'm not here. Otherwise, this legislative session so far pretty quiet for us. Not necessarily quiet up there, but I have not been there yet. Any questions about any of that? litigation per usual will take an executive. We get started with the first case.
Sure.
Before we get started with the hearing agenda, I just want to remind everybody that the commission's confidentiality provisions require that we not use the name of anybody who is not a named party to the complaint. So we have often given those people pseudonyms or the entity pseudonyms. Please use those, or just use somebody's title or relationship instead of using their name if they are not a name.
Okay, the first case is E24-0021 A and B, Christopher Graves versus Tamara Hartley, and Sodexo. It is an employment case. The recommendation is for the commission find no reasonable grounds on all three counts. And therefore we will hear from complainant.
Is there anybody here for respondent in this case?
Oops.
It should have somebody, yeah.
Hold on.
I didn't see
No.
her in the. Okay. Corey, you have 10 minutes. Do you want to? I would usually ask if somebody wants to reserve that time, but there's just one that's not here. I think that's better.
I'm sorry, I may have missed some of that. The audio isn't very clear. I hear that the commission is asking that if anyone is here for the respondent, and it doesn't seem so. Was the commission asking me if I wanted to reserve any time?
Yeah, so usually I say you have 10 minutes total. Do you want to reserve any of that time to respond to the other party? Since the other party is here, I'll leave it up to you in case they show up in the middle of your presentation.
Sure, I'll reserve 2 minutes in case they appear.
Whenever you're ready, go ahead.
You know, before we get started, I
Yes.
just want to echo what Attorney Perry just said. From my perch out here, the audio is fairly poor via the remote, and so I think that folks are having a hard time understanding what's being said in that room, and I don't know if that can be improved, but it is fairly poor.
Yeah, because they might be coming through my computer.
Oh, that was just better.
Really? Is that better now? I mean, I'm standing in front of the microphone.
No, that's not good, actually.
That's not.
It's unusually difficult to hear.
Yes.
We have had some technical problems today. I'm trying to figure out.
Okay.
What's the end?
There, how about that? Better?
Sounds a little crisper. Let's see how we do.
Can you hear me now?
Yes.
Yeah.
Okay, great. I think that's a regular mic and it is on. We'll just move it closer to our tables since there's nobody in the room to present. Okay, Attorney Perry, whenever you are ready, you have 8 minutes on the clock.
Fantastic.
Thank you very much. Good morning to all commissioners and the Maine Human Rights Commission. My name is Ashley Perry, and I represent Christopher Graves, the petitioner in this matter before you today. I address the commission today to supplement the written submission provided in advance of today's hearing and to ask the commission to reject the investigator's report in this matter. The facts of this case involve a clear ongoing pattern of disparate treatment, retaliation, and violation of both Sodexo's internal policies and the Maine Human Rights Act. Mr. Graves was hired in January of 2023. Very early into his employment, Sodexo seemingly began creating a questionable disciplinary record for Mr. Graves. For example, Throughout this proceeding, Sodexo produced a written coaching purportedly from February of 2023, allegedly related to Mr. Graves's attendance. However, that record is unsigned by both management and Mr. Graves, and there was no evidence that it was ever actually discussed or presented or shown at all to Mr. Graves. More importantly, Mr. Graves provided records proving that it was impossible for him to have received it and for him to have been present with Sodexo on the date purported on that record. Additionally, Sodexo accused him of calling out of work on a date that is contradicted by his pay records, which actually show that he worked more hours than he was scheduled, so he could not have missed an entire shift. And these inconsistencies in Sodexo's records provided to the Commission suggest that these records were manufactured discipline to justify later adverse employment actions. The records also show that Ms. Hartley repeatedly sought to terminate Mr. Graves, despite being told by Human Resources that Sodexo policy prohibited termination while his criminal charge remained unresolved. In multiple emails, Ms. Hartley made clear that she wanted him fired, even though he had not been convicted of anything, and that charge was ultimately dismissed. After Mr. Graves returned to work in August 2023, Sodexo again relied on unsigned and disputed written warnings that Mr. Graves never received. Then, in September 2023, Mr. Graves raised a concern about unequal pay, specifically questioning why he, as one of the only Black employees working in the kitchen in Sodexo, was paid less than Sodexo's own job postings. Although Ms. Hartley acknowledged that he should be earning more, his pay was not corrected, and instead he was suspended under the guise of an investigation, and Sodexo's Human Resources later confirmed that there was no approved suspension request in his file. In November 2023, Mr. Graves was placed on leave again due to a jail intake record that Sodexo falsely treated as a new arrest. In reality, it was a related matter that Sodexo already had known about and was already presented on his background checks, and there were no new charges. Nevertheless, Sodexo terminated Mr. Graves in March 2024 based on vague claims and these incorrect assumptions without even properly notifying him until the commencement of this the Maine Human Rights Commission proceeding. The evidence presented throughout this proceeding supports a finding of discrimination and retaliation under the Maine Human Rights Act. Sodexo's stated reasons for discipline and termination were not legitimate, but were rather pretextual and a result of discriminatory motivation. Mr. Graves respectfully requests that the Commission reject the investigator's report and find reasonable grounds to believe that Sodexo and Ms. Hartley discriminated against him based on race and unlawfully retaliated against him for engaging in protected activity. Mr. Graves and myself thank the Commission for the time and attention to this matter today.
Commissioner, questions for Attorney Perry? Commissioner Sanders. Good morning, Attorney Perry. I'm curious about a portion of your presentation in which you talk about prior disciplinary action that the respondent issued, allegedly, you say, to your client. Curious about whether your client at the time that those disciplinary actions either were or you allege were not issued. Did the supervisor talk to him about those disciplinary actions? I understand you're saying that there was no sort of written documentation given to your client, but I'm curious about whether those discussions may have been had verbally.
No, and so in the fact-finding session, Mr. Graves indicated that he was not part of conversations about the two, specifically the two actions that I referenced, that Sodexo had these written write-ups that they presented to the Commission. But Mr. Graves was not part of a conversation of those, did not talk about those with the supervisor or Ms. Hartley. There was one write-up or note in his file about a time that he was working the cash register and the cash register was $20 short. And he did recall a conversation with his supervisor about that. And he indicated to the commission that he actually, as soon as that incident happened, he replaced that money with his own money. He didn't know how his cash register was short that day, but just decided to fix it anyway. And that was the only disciplinary action that it showed in his file and was brought up in this proceeding that he was actually aware of or part of.
Okay. And just to sort of put a finer point on it, with respect to the February disciplinary actions, is the first time that your client became aware that those even existed was in the course of this proceeding?
Yes, that's right.
Okay, thank you.
Mhm.
Other, Commissioner Douglas.
Yes, good morning, Attorney Perry. So I understand your argument to be that your client was not treated as well as some of the white folks that were working there, right? That's the crux of it. And I see that you've got some specifics here with respect to pay, which are dealt with in the investigator's report. And I also see at the end of the report there's a sort of isolated remark from our perspective where he's referred to as we're going to get rid of his black ass or words to that effect. I'm wondering what your best argument is in terms of this disparate treatment. How do we tie this to race? I mean, if I'm trying this case, I'm sort of thinking that this woman has a problem with the fact that this guy's in and out of the judicial system, right? She doesn't want this sort of person hanging around. What's your best argument that this is racially motivated?
That comment in the affidavit that was presented to the commission is extremely telling of racial motivation from Ms. Hartley. And that comment in particular, and then paired with Ms. Hartley being the driving force from essentially the start of Mr. Graves's employment, of these internal records showing her conversations with her HR department and continuously pursuing this and continuously trying to get Mr. Graves fired, even though she was repeatedly told that that was not happening, and then later suspending him without receiving approval from HR to suspend him. And then again, that comment that you referenced, in addition then to the last suspension being right after, immediately after Mr. Graves approached her about him receiving unequal pay compared to his colleagues and counterparts and the open positions. Really, all of these things together is what paints that clear picture.
Right. Okay, I hear you. And in the record, is there any determination or exploration of whether or not Ms. Hartley treated other minorities there in a disparate way? Was there any treatment of that?
There, from my perspective, Commissioner, I believe the records are inconsistent or at best not very clear regarding the statistics for Sodexo's employees and the makeup of Sodexo's employees. And specifically, Sodexo is a very large company, and they have these various aspects and various areas of employment that they obviously have staffed around, specifically around the college where Mr. Graves was working, but also outside of it as well. And so I think the records are very unclear to show really how many other employees Sodexo has that are non-white employees and what their pay scale is. And so I believe the records are really insufficient to show, to be able to inform the commission fully on that.
Right, right, okay. And I guess one last question for now. The issue about the pay, right? So the investigator's report says your client was paid more than 10 other cashiers, 9 of whom were white, 1 of whom was biracial. So what's your best argument that the pay is evidence of disparate treatment here?
Well, I didn't find that their records supported that either, and I didn't find that their records really accurately reflected the sort of pay scale in that manner. What the records do reflect is that Miss Hartley agreed with Mr. Graves that he was being paid less than the counterparts in the kitchen where he was working, so in the area where he was working, and said that his pay, I believe she indicated that he should be paid more and that his pay would be fixed, but then the suspension and investigation came immediately after that, so that never occurred. So I believe the pay scale records, they're just insufficient and incomplete in front of this commission to be able to glean reliable information either way about that.
All right, thank you. I appreciate that.
Thank you.
May I speak on that to you, Mr. Douglas, as well? I'm
No,
Chris Graves.
hi, Mr. Graves. No, at this point, it's just your attorney speaking.
Okay.
What I suggest, Mr. Graves, is that your attorney's going to have another chance to speak. Maybe you send her a little message.
Got you. Thank you.
Okay.
Commissioner David?
So, Attorney Perry, you start your argument by saying that the disciplinary records that are not signed, you make an accusation that's rather stark. You're saying that they're laying the groundwork for future action. It's your position that Hartley is after him from the beginning. Is that correct?
It is. The records that Sodexo has provided, we don't have internal records to show when these were created or when they were created in their file. There's no timestamp or anything in the creation of these records. We see the date on, for example, a write-up. We see a date on the write-up. But again, really significantly, it says on that write-up that it was given to Mr. Graves that day, but in February of 2023, it's indicated on a day that he was incarcerated, so he could not have physically possibly been present to do that. And so there is a question. Again, without having information of when these records were created, we don't know if they were created in advance of action or after disciplinary action was taken to add to his file after the fact. We don't know that, but we do know that he could not have been present to receive it. The dates do not match a date that was possible for that to happen. A write-up of calling out cannot match the pay records that Mr. Graves presented to the commission. And so we see that their records aren't lining up and aren't matching up, and we don't know when they were created and put in his file.
It is Respondent Hartley that makes the specific racial comment, which is the only one we have in the record about firing him with the racial epithet.
Yes.
Okay, and you say that Respondent Hartley is fixated on the criminal cases. Would you comment on what in your view is the legitimate import of the criminal cases? Are they legally able to make an employment decision based on criminal convictions on those charges?
No, because the initial, and I think that this sort of record of how this happened with the criminal charges and the background checks, I think this can be easily sort of conflated or convoluted, but sort of breaking up the timeline of that, the initial problems with Miss Hartley started with a particular charge that was then later dismissed. But when there was any sort of legal action that related to that charge was when Miss Hartley each time again tried to get Mr. Graves fired, regardless of the outcome of that. And so within that time, there was, I guess, sort of related legal action that she was seeing, and it's unclear how she was obtaining this information from a website, but it's clear that she's not looking into the jail website to see what this is. And so anytime there was reference of any sort of legal involvement, these records show that Sodexo, and specifically Ms. Hartley, was treating this as new charges every time. And in reality, that's not at all what was happening. And
There's
so
only one charge?
there's two charges. There's one charge, and then that was dismissed, and later when that was referenced. And then shortly after that, there was a charge related to conditions of release from that first charge. And then that resulted in a misdemeanor criminal conviction, which Sodexo knew about and did not take action to terminate or suspend him at the time of that conviction. He then continued employment and did this second stretch of his employment at Sodexo.
How long has he continued to be employed after that? I mean,
I would have to double check the date, but I believe that would have been, at least when the second semester, when the next school year started. So in the fall, like August, September, the rest of his employment there would have been after that misdemeanor conviction that Sodexo knew about.
do we know on the record whether Hartley directly supervised any other employees of color in that local situation, whatever it was? I'm not sure which university campus it was, but
I don't think Sodexo's records show that at all. My client, Mr. Graves, informed the commission that there were not other employees of color in his working area, in his field, in the area that he was staffing in the kitchen, and that would be Miss Hartley's supervisees. But Sodexo's records really did not include any of that information.
And the last question, following up on what Commissioner Douglas asked you about the wage issue, am I correct that your claim for the whistleblower count is saying that it's retaliation solely for asking about that wage disparity and why am I being paid less?
That is part of it, because the suspension happened immediately after, but then also Mr. Graves' termination, he did not find out that he was terminated until he initiated this Maine Human Rights Commission proceeding. He did not find out that he had been formally terminated.
I don't understand that. He knew he wasn't going to work. How?
Well, there was several of these suspensions, so he was within a administrative suspension.
Oh, I'm sorry. You're distinguishing between suspension. He knew he was on suspension, but your position is he didn't know he had been terminated.
Yes.
They never communicated that to him in the record?
No.
Okay, thank you.
Commissioner Sanders. Sure, just one follow-up question. If you look at page 4 of the investigator's report, there's a really important fact embedded in footnote 7, which is sort of almost the entire way down the footnote. There's a sentence that reads, second to the last sentence, quote, finally, respondent provided that supervisor was not involved in the discharge decision, end quote. If that's true, then how do you prove your claim that the discharge was based upon this supervisor's discriminatory animus, right? So if she wasn't a decision maker in the discharge decision, how do you get around that in your case for your client?
Well, even if she wasn't the final say, she was still the person leading this and pursuing his termination from the start. and continuously reaching out to human resources to try to get him fired, ask if they can fire him yet, ask if this is enough to get him fired, and still leading the charge on that. And then the sort of final misunderstanding of Sodexo's was seeing, because they saw an intake on the Franklin County correctional facilities, the jail's intake website, because they saw him listed there, they interpreted that to be new charges, assumed it was new criminal charges without looking into it, without discussing it with him at all, without really trying to figure out at all what it was, assumed it was new criminal charges, and then assumed that there was new information on a criminal background check and use that as the grounds for termination. So even if she wasn't the final decision maker, she was still the person leading this charge and providing this information to human resources with the stated purpose of trying to get him fired. And then their last misunderstanding of what that record actually was then what provided them the basis to terminate him. And that was obviously an incorrect misunderstanding and also, but directly related to Ms. Hartley's actions throughout his entire employment.
Thank you. Commissioner O'Brien.
Good morning. Could you just touch on, because I don't think I heard you talk about it, the incident of touching a student's hand, and also that students complained, according to this, students complained that they felt uncomfortable about having their contact information written down and asking them to be character witnesses. Could you touch on that?
Yeah. So regarding the allegation that there was a touch of a student's hand, that was something that I don't see really reflected in Sodexo's decision making or much in their records. It was a disputed fact in this proceeding, whether that really did play a role in this, and whether that accusation even was really from a student, or obviously that student wasn't part of the fact-finding process in this proceeding, so she was not there to talk to the commission, did not provide a written affidavit or anything like that. Regarding the other example that you brought up and the other accusation that Sodexo made, that is unfounded also, because there isn't anything. First of all, there aren't any records supporting that there were any students that felt uncomfortable being asked to write sort of a letter of recommendation or provide a statement of recommendation. The records supplied by Mr. Graves to the commission show that if anyone voluntarily wrote sort of a statement in favor of Mr. Graves, like a recommendation for employment, that they did not have to write their full name, they did not have to write their contact information, they didn't have to write anything. It was just people who voluntarily, if they wanted to write a letter of recommendation, which included one of Mr. Graves's direct supervisors through Sodexo at his employment, someone under Ms. Hartley, but direct, like within his employment shift, someone who wrote a recommendation to him in that notebook as well, but they did not provide any contact, or no one writing in there had to provide any sort of personal contact information. And Sodexo's own records in their email chain with human resources, I believe, referenced that he wasn't violating any policy or doing anything that he wasn't supposed to be doing on campus. He was just asking people if they voluntarily were willing to sort of write a statement to support his employment. But again, the timeline here, and really when the disciplinary actions started and when Sodexo took action, relates to Sodexo's motivation. So those incidents with the students were not when Sodexo initiated administrative suspensions or when Sodexo officially terminated Mr. Graves.
Okay.
Thank you.
Anybody here for Sodexo or Tamara Hartley?
I did double check.
It went to them, the commission.
Yeah, and I did see an email from respondent's attorney. It sounds like they were not intending to be here.
Okay, great. Then having heard from complainant's attorney, we'll hear from the investigator.
My name is Carrie McCarter. I am the investigator assigned to this case. I don't have a whole lot. I'm open to questions. I guess I'll just, Attorney Perry came on this case after it closed, so was not actually present at the IRC. Carrie, can you speak? Oh, I'm sorry. Chris Graves' attorney didn't come onto this case until after it was closed and was not present for the IRC. So knowledge that she has from that comes only from her own client. The first charge, the dismissal of the domestic violence terrorizing, we just want to clarify that that was dismissed because of a plea deal related to other charges. During the IRC, respondent clarified, particularly for one of the instances, there was a incorrect date. February 7th was supposed to be February 17th. On February 7th, Mr. Graves had called in and said he wouldn't be there, but he did end up coming in. So there was just a mix up around that date.
Commissioner O'Brien?
Thanks. Attorney Perry said many times about that she couldn't try, or she didn't believe that the records, the employment, the records of any employee, numbers of employees or pay and all that was substantiated, and she didn't really believe that. Could you speak to that?
I mean, I think we have the respondent submitted the pay of other employees, I think at the same location where he was working. And I think I provided that in here. As far as who,
but I guess, did you feel comfortable that the respondent provided enough employment information?
Yeah, I mean, I think the pay issue, there were two pay issues. When he first started, he was supposed to be at 15. His first paycheck was, 15 hours. First paycheck was 15 hours. And once he saw that, he went to somebody for a respondent, and that was corrected as of the second paycheck. The pay issue is really around seeing them post for new employees at a higher pay rate, which, I mean, I think we probably all seen companies do. It just, there didn't seem to be any connection to race. It was more trying to hire people.
What do you think the importance of the criminal charges are? And also, would you respond? I mean, you start by saying you want us to know that it was just a plea deal. Like we're supposed to assume that he really is convicted of that, but it's not because it's a plea deal. I mean, what are you trying to say with that?
I just wanted to share where, they keep saying that, but the charges were dismissed. But they were dismissed because there was a plea deal, not because.
So what's the relevance of the charges or the status of a conviction for a domestic incident?
I mean, my understanding, I could be wrong, but I think Maine is an at-will state and people can be dismissed for, many different reasons. I think our concern here is whether or not it's discriminatory.
So what do you do with the racial comment that we do have?
So the respondent denied it. She said she didn't make it. I did find her credible. I spoke with her during my IRC. This was really coming from a third party. After the fact, I mean, it's really just unsubstantiated. And even if she had said it, you know, she didn't have a role in the discharge decision.
Well, clearly her position is communicated to HR, is it not? What do you do with the double attempts to say, can I fire him now? I mean, that's my view of what they're arguing for that second one.
I think it shows that she didn't have a role in discharge decision. I think if she had her way and she did, they would have fired him sooner.
Why?
Because I think when you see a domestic.
No, on what basis would she say the firing was justified sooner? The criminal situation?
Yeah, like that's where the first request to fire him came from, was after the domestic terrorizing charge.
So.
Thank you. Okay, we have heard from complainant and we have heard from the investigator. We'd be looking for a motion. There are 3 no reasonable grounds recommended findings.
Yeah, before we vote, I'm curious, is there a representation from respondent as to why they're not here today?
I mean, I could read the email.
Sure.
Do that, please.
I don't know.
Sodexo has reviewed the hearing rules. We support Investigator McCarter's initial findings and have nothing further to discuss at the hearing on February 9th.
Okay, so I would move that first we take that first proposed finding, and I agree with that. I think we say there are no reasonable grounds to believe that Tamara Hartley and or Sodexo discriminated against Mr. Graves on the basis of sex.
Second.
Been seconded. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders? Yes. Okay.
Okay, so then I would next move that with respect to the second proposed finding that there are reasonable grounds to believe that Ms. Hartley and or Sodexo discriminated against Mr. Graves on the basis of race and or color.
Second.
Discussion?
Yeah, just an observation. I think Commissioner Douglas, to follow up on your question about why respondents counsel isn't here. Candidly, I'm disappointed that respondents counsel isn't here. I think it's important for respondents in this state as a demonstration of respect for this process, for the complainant, for complainant's counsel, for commissioners, for commission staff to appear at a hearing, notwithstanding the fact that the investigator's report may demonstrate a recommended finding of no reasonable grounds. I just want to make sure that that's on the record, and to the extent that, respondents and their counsel are considering sort of how to handle an investigator's report. From my perspective, again, very important for respondents counsel to be here, to participate in this process, and to be available to answer commissioners' questions.
Well, Commissioner Sanders, let me just say that you and I are on exactly the same page with that. I'm very disappointed that respondent and their counsel are not here. I think there's a lot of problems in this file. The documentation in complainant's file I find to be highly suspect. The misleading report about his his reappearance at the jailhouse I find troubling. In terms of evidence that this is tied to race, I would just go ahead and recite the stats in the investigative report on page 5. There are 10 cashiers listed, 9 of whom are white, 1 of whom is biracial. There is a Hispanic person referenced in here. I don't see any other African Americans listed in the report. Maybe I missed that, but I don't see it. And then the comment about the black ass, his black ass, we're going to get rid of him. This woman trying to terminate him multiple occasions against company policy. I've got a big problem with this file, and so I'll be voting yes.
Commissioner David?
I concur, and I concur with Commissioner Sanders' well said disappointment that the Respondents' Council is not here. The tendency is to retaliate against them for not showing up, but that's a separate issue. In terms of this motion, racial discrimination is so difficult to figure out and to attribute. You look for a comment, and you do have a comment here, and that's sufficient to put it on the table. And then you do have a woman that doesn't understand twice. She clearly is trying to get a reason to get rid of them. It's troubling that the employment records are not well documented, and whether or not Attorney Perry is correct that they're sort of after the fact to paper the file. I don't know. It leaves me back to the standard that a trial might sort this out. So by that evidentiary standard, I think it's as likely as not that complainant could prevail at trial, and by that standard, I'll be voting yes on the motion. Yes, because it's framed that there is discrimination, yes.
Well, I totally agree about the disrespect with the respondent not showing up. And I'm glad it is on the record. However, as Commissioner David said, that the tendency is to say, all right, you're not showing up, then some type of retaliation on our part, but I just cannot see. I cannot make the connection. I think, and I think to race, and I think listening to our investigator, I mean, Attorney Perry made the comment several times about the lack of evidence with the employment issues of the other employees, also about the pay and about how many and she said she can't trust it, but that's why I asked the investigator, and that I'm going to go along with the report.
I think there are nuances of whether there was discrimination tied to race, that having the respondent's position and perspective would have been helpful. And without that, I think I will go along with the motion that there are some unanswered questions that they could have helped fill. So I don't consider that retaliation. I think it's more, we're missing some information that might have helped us.
Any further discussion? Seeing none, the motion is to find reasonable grounds on the second proposed finding. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Okay. So we have one more proposed finding. Commissioner David.
I'll move that there are no reasonable grounds to believe that there was retaliation under the whistleblower statutes.
Second.
It's been seconded. Discussion.
Speaking to that, it just seems to me that the primary claim there is about inquiring about the pay, which is a fairly routine thing, and I don't think that that's a justification to find that there's unlawful discriminatory animus, that he's reporting something that those statutes require, and an unlawful situation being reported, and that therefore there's retaliation. We've already found that he was unlawfully. We believe that there's reasonable grounds to believe that he was unlawfully discriminated against, not in terms of retaliation.
Any other discussion? None. The motion is to find no reasonable grounds on the third finding. If you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien? Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Sanders? Yes. So we have split finding, no reasonable grounds on the first and third findings, reasonable grounds on the second. The parties will be sent a letter informing them of the next steps.
Next case for hearing is
Thank you very much, Commission.
employment case E240025 A and B, Teresa Marquardt versus Midwest Veterinary Partners. It is a split recommendation, but includes one recommendation for a finding of reasonable grounds on one count, and then a recommendation of no reasonable grounds on two others. But I think that the finding of reasonable grounds ought to be considered the more important, and therefore we would hear from respondent first.
Good morning, Attorney Parsons. You have 10 minutes. Do you want to reserve any of your time?
Yes, please. I'll reserve 1.5 minutes.
Hang on.
You're welcome.
All right. I got 8 minutes and 30 seconds on the clock. Whenever you're ready, go ahead.
Good morning, Commissioners. I have the pleasure of representing Missionary Veterinary Partners in the matter before you today. MVP objects to the findings of reasonable grounds as to Ms. Marquardt's discrimination claim and agrees with the finding of no reasonable grounds as to the retaliation and hostile work environment claims. The reasonable grounds finding is based on the omission of critical evidence, misinterpretation of the evidence, and misapplication of the law to the record evidence. Namely, the investigator omitted evidence of Ms. Marquardt's performance issues and erred in concluding that Ms. Marquardt performed her job satisfactorily, erred in identifying Ms. Marquardt as the person who sent a text on March 31st, and omitted critical evidence undercutting Ms. Marquardt's veracity. Ms. Marquardt was a vet tech assistant who MVP hired in August of 2021 after acquiring her predecessor employer. Ms. Marquardt reported to SC, the lead vet tech. SC created the schedules, handled callouts and vacation requests, and ensured that vet techs performed their responsibilities. During the IRC, SC explained that when techs called out of work, she frequently filled in for them. MVP promoted AP to the hospital manager role in October 2021. AP remains employed by MVP today. Dr. NC was employed by MVP as the director of medicine for the hospital and has practiced veterinary medicine for nearly 60 years. Ms. Marquardt spoke openly about her addiction and recovery with her coworkers, including hospital manager AP, describing her coworkers as very supportive during her employment. When she shared with her coworkers that she was looking forward to her 1-year sobriety date, AP asked if she would be comfortable with a small celebration, and with Ms. Marquardt's permission and her own personal funds, AP purchased a cake, flowers, and a card that Ms. Marquardt's coworkers signed. Nonetheless, Ms. Marquardt exhibited performance problems, frequently called out, left shifts early, and was late for shifts throughout her employment. The record reflects that AP and Dr. NC frequently provided verbal counseling and coaching to Ms. Marquardt. SC spoke with Ms. Marquardt about her attitude, motivation, and work ethic. While the vast majority of the coaching occurred verbally and was not documented, the lack of documented counseling does not suggest that it did not occur. Ms. Marquardt's attendance issues impacted her coworkers, who frequently were left scrambling when she called out on short notice. Aside from the call out, she often spent time in the bathroom for hours and spent time on her phone in treatment rooms rather than working during her shift. Over time, her relationship with coworkers devolved because she gossiped about her managers and was not a team player. In particular, Ms. Marquardt's aggressive behavior toward AP escalated, having her yelling at AP and taking a disrespectful tone when asked to complete routine tasks. According to Dr. NC's statement, Ms. Markhart was a problem from the start. She was not confident in her skills as a vet tech despite training. She had issues with temper, attitude, gossiping, oversharing of her life, and personal difficulties to the point of discomfort to the listener. Together with AP, Dr. NC had many meetings with Ms. Markhart on how to effectively deal with her issues. During the IRC, SC explained that it was difficult to schedule Ms. Markhart. She was not confident in restraining animals. There were personality conflicts, and some of Ms. Markhart's coworkers and veterinarians did not want to work with her because they felt unsafe about her handling of animals and were concerned that they would be bit. SC pulled her aside for 3 to 4 weeks to work with her on handling skills based on feedback from the vets. These concerns about Ms. Markhart's performance are consistent. She struggled to safely restrain animals. She frequently called out. Her coworkers and the veterinarians did not want to work with her because of the unsafe handling and resentment about her call-outs. Both AP and SC described this during the IRC, and Dr. NC did so in her written submission. On March 23rd, when Ms. Markhart informed AP she was starting Suboxone treatment, Ms. Markhart herself described that AP was supportive, asked how she could help, and told Markhart to do what she needed to take care of herself. Markhart complained that AP was only supportive in that moment, but the record does not establish that. During the IRC, Ms. Markhart states that she believed AP contacted People Solutions in order to terminate her employment. The following week, Ms. Markhart was late for 2 shifts without notice, and SC issued a written warning, but assured her that she would not be fired for the attendance issues. These late arrivals were different from the previous late arrivals, which were scheduled before the actual shift began. During the week of March 22nd, her late arrivals were just late arrivals without any notice and any ability to cover those shifts. Contrary to findings and based on her misinterpretation of text communications, it was SC who contacted Ms. Markhart on March 31st to check on her. Ms. Markhart was home that day and not scheduled to work. SC informed Markhart she felt ill and was leaving work early, but would come and help Markhart look for her lost cat. This is critical as the investigator's determination rests in part on her mistaken belief that it was Markhart leaving early on that day and that MVP penalized her for this following her treatment discussion with AP. Over a week later, on April 10th, Ms. Markhart informed SC that she would be late for her April 11th shift to a medication appointment, and SC had no problem with this. Upon arriving to work on the 11th, however, instead of heading to the treatment room or engaging in work responsibilities, Ms. Markhart went to the break room and was drinking coffee and chatting with her coworkers. Unaware of her late arrival, permitted or otherwise, AP entered the break room and instructed all of the techs to get to work and stop the chit-chat and dilly-dally. Consistent with her own admissions during the IRC and her general disrespect for AP, Ms. Markhart yelled at AP in front of her coworkers and patients. Notably, the investigator's report states that verbal altercation ensued and does not address the party responsible for the altercation. AP was done at that point. Being attacked by Ms. Markhart that morning was the last straw. Anticipating Ms. Markhart's reaction, she waited until her regional manager could be present to assist with terminating her 2 days later on April 13th. MVP discharged Ms. Markhart after years of frequent call-outs, rude and disrespectful conduct, and performance deficiencies, which resulted in veterinarians who did not want to work with her. AP made the decision to terminate her employment when Ms. Markhart verbally assaulted her in front of coworkers and patients just because AP told her to get to work. AP was not even aware that SC gave Markhart permission to arrive late on the 11th. During the IRC, Ms. Markhart informed the investigator that she definitely has an attitude. I definitely was disrespectful at times, she said. There were definitely moments in 2 years, absolutely, that I was disrespectful, according to Ms. Markhart. It's critical here to look at what's consistent. We have evidence that Markhart was not performing well and was rude and aggressive with AP. Markhart herself admits this, and it is supported by the testimony of SC, AP, and Dr. NC. There is absolutely no evidence in the record suggesting that AP, who was still the hospital manager 3 years later, had a propensity for yelling or aggressive, disrespectful conduct. There is no likelihood that she would have initiated a verbal altercation with Markhart on the 11th. Further, Markhart testified during the IRC that she thinks she was discharged because she told the truth to AP, because she spoke up for techs and She didn't think that AP liked that. This is inconsistent with believing that she was terminated based on her alleged disability or any allegations regarding the same. Respectfully, the investigator's determination that Marquardt performed satisfactorily as support for a prima facie case and her decision to ignore consistent evidence presented by Dr. NC, SC, and AP resulted in an erroneous finding that is contrary to the evidence. Further, Ms. Marquardt presented no evidence establishing that MVP's legitimate and non-discriminatory reason for her termination was pretext.
That is your time.
Thank you.
Well done. To the second. All right, Commissioner Sanders and then Commissioner O'Brien.
Great. Good morning, Attorney Parsons. I'm curious about the verbal altercation that you described, and that's reflected in the investigator's report and in your rebuttal as well. Can you lay out with some, pretty good granular specifics, what exactly was that verbal exchange?
So AP, who is the hospital manager, is at work early and walks into, she's, walking around the facility, obviously, and treatments have begun. It's obvious that staff is sitting in the break room. One of those staff members was Ms. Marquardt, who was making coffee, chit-chatting, and laughing with her coworkers. And AP's purpose in going into the break room to tell them all to go back to work or get to work was not even targeted at Ms. Marquardt. She went in there frustrated that none of the vet techs were doing what they were supposed to be doing. It was late and beyond the point at which they should have been handling their responsibilities, and instead they were chit-chatting and drinking coffee. This is the point at which Ms. Marquardt became very verbally aggressive with AP. She yelled at her. I don't know the specifics of what Ms. Marquardt said to AP, but AP provided testimony that Ms. Marquardt's communications with her had been escalating and becoming more and more aggressive and volatile. So Ms. Marquardt likely was just mouthing off about the fact that they were told to get back to work. But it turned into a verbal altercation, which involved coworkers and patients hearing Ms. Marquardt yelling at AP, I suppose telling her that she had permission to arrive late, or, she was getting her work done or about to enter the treatment room. I don't understand or know exactly why Ms. Marquardt was so angry, but it was sort of part and parcel of her typical responses when AP asked her to get to work and do her job.
Okay, thank you. And I think I see complainants, counsel or representative here as well. And so when it's time for, questions of complainants representative, my hope is that you can describe, with good specificity, what exactly did the complainant communicate to AP in that verbal altercation?
And again, to clarify, AP, this had nothing to do with showing up late. This was related to the fact that they were sitting in the break room, dilly-dallying and drinking coffee when they should have been in treatment rooms.
Thank you.
Commissioner O'Brien.
Thank you. Just a point from the first sentence of this report, it has bothered me. Could you explain that complainant, it says is a dental hygienist?
I'm pretty sure that's a typo, Julie.
Is it a typo?
Yes.
I thought it might be,
I know, full service thing.
You can check with the investigator when they come up, but I'm pretty sure it's a typo.
Okay.
And with all due respect, I'm certain that it's a typo. However, I do think that it is evidence of the haste with which some of these reports have to be completed.
That didn't do it. Yeah, it's the first thing I noticed.
All right. Any other questions for Attorney Parsons? Commissioner David.
Attorney Parsons, in paragraph 20, the second to the last paragraph before the recommendation, the investigator says that respondent stated that her absences and tardiness were a frequent problem for which she had previously been disciplined. However, there's no evidence in the record of that. Is that correct, that there's no evidence of any previous discipline previous to her disclosures about medication.
I disagree that there is no evidence in the record of that. There are 2 points here. Number one, we have AP, SC, and Dr. NC explaining that this was a consistent problem. The fact that it was not documented prior to, and I'll explain what differentiates the other late arrivals, but the fact that it was not documented does not mean it didn't happen. We have plenty of evidence, consistent evidence from SC, AP, and Dr. NC that she was frequently late and not available and calling out. Those call outs.
The answer is that that's all testimony, correct? And no documentation.
Correct.
Okay.
The call outs, the distinction here is that the call outs prior to her disclosure that she was going to be using Suboxone is that she would call out a couple of hours in advance of her shift. So there was typically time for SC to either find someone to fill the slot or for SC herself to fill the slot, because it all came down to SC when someone didn't show up.
Same question about in that paragraph, 2 sentences later, the investigator says there's no evidence in the record about alleged performance concerns and disrespectful attitude, that there was no documentation. Is your answer the same, that it's in the testimony at the IRC?
No, it's not in the testimony. Well, it is in the testimony, but there are documented warnings. I think one was from July of 2022 and one was from December of 2022, where she is specifically written up for rude, aggressive, and insubordinate conduct. I'm pulling that right now, but there are 2 warnings related to that. And just to clarify, again, the late arrivals during the week of March 27th, there was no contact to inform MVP or anyone at MVP that she was not coming in or was late or anything like that. So the distinction is that she just showed up very late, or MVP contacted her and asked, "Are you coming in?" The other important distinction is that that's not the reason she was terminated. She was terminated because she yelled at her manager and had been yelling at her manager for 2 years at that point.
For 2 years? Okay, thank you.
You're welcome.
Any other commissioner questions for Attorney Parsons?
Just a comment. I want to take a moment to respond to the comment that Attorney Parsons made a moment ago, characterizing the general work product that the investigator has produced here. I'm going to encourage my fellow commissioners to not give any weight to Attorney Parsons' remark, simply because there may be an error in the opening paragraph of the report is not a commentary nor a referendum on the general quality of the work product that we have here. So I want to make sure that that's on the record.
And I want to actually thank you, Commissioner Sanders. I had planned to address this when I had a break in the questioning. I think sometimes it feels like there is a rush because sometimes the report doesn't go out until, in this case, the report was issued about a month before the 2-year statute of limitations. In fact, the report went to legal for review 3 months before the statute of limitations ran. It has been reviewed by more than one person. The fact that that typo didn't get caught is just a commentary on the fact that you're all human and sometimes we miss things. It's not a rush job. This report was drafted with the same standard that we expect and see from our investigators all the time. So just gonna put that on the record and we'll move to complainant's attorney. Attorney Gabriel, I did wanna just mention that because the complainant did not submit any disagreement, we are only dealing with the reasonable grounds finding. We're not hearing argument on the no reasonable grounds finding today.
That is correct, thank you.
Did you wanna reserve any time, Attorney Gabriel?
I'll reserve 2 minutes.
Okay, whenever you're ready, go ahead.
Thank you. Good morning, all. As you know, my name is Attorney Catherine Gabriel. I'm here on behalf of complainant Ms. Marquand. Complainant believes that the reasonable grounds finding was certainly properly issued here and should be affirmed today. Reasonable ground standard, as you all well know, it does not require a complainant to prove her entire case at this stage. The reasonable ground standard is interpreted to mean that there's even a chance of complainant prevailing in a civil action. And we certainly believe that that standard was met here today, specifically to the disability discrimination as it pertains to the wrongful termination. Respondents claim that complainant was fired due to her ongoing attendance and disrespectful attitude. But the reasonable grounds finding properly concluded that respondents did not have a history of discipline as reflected or lack thereof in complainant's file. What you do see in the record is that respondents disciplined complainant on March 30th, 2023, after complainant called out. She did contact respondents. She had put them on notice of her disability flare-ups. This had been formally documented with medical documentation from complainant. And she did call out and specifically connected it to feeling bad from her medication. She is then disciplined that same week for her attendance at that point. Prior to this specific discipline, there is no evidence of discipline on her record related to attendance. She was not formally disciplined. Her testimony at the Issues and Resolution Conference confirmed she had not been disciplined or spoken to in a negative manner about her attendance prior. So for respondents to say there was an ongoing history of attendance issues, it simply doesn't, it's not reflected through the record, and the investigator, that is the crux of the investigator's finding here, and certainly why we see the reasonable cause finding is accurate. In terms of the reasonable grounds finding, it also concluded that the prior discipline was just simply not there. And so, for testimony also to, ultimately the testimony did not reflect that there was any prior attendance issues, but the discipline that Attorney Parsons cites you today, to be clear, that discipline was issued months and months prior to her termination. There was certainly one written warning that was related to complainant's cell phone usage. And then there was a written warning related to completing general work tasks. These discipline actions were from at least 9 months prior to the termination. They didn't give rise to a termination at the time. They were not significant enough misconduct or issues to result in final written warnings or let alone a termination at that point. There is also evidence on the record that other employees had numerous disciplines and for similar reasons and were not terminated. There is certainly some dispute of fact in terms of how many other employees had specific steps of discipline, but we do believe there's enough evidence here to support that there were certainly comparators who had other discipline and were not similarly terminated. Ultimately, complainant also requested an accommodation to arrive late on April 11th of 2023. This was granted by Lindsay Anderson, the head scheduler. This was communicated and confirmed between Ms. Marquardt and Lindsay Anderson. When complainant arrived later that day, she was approached and confronted by her manager. Attorney Parsons has referred to her as AP. That's Mrs. Pasella, the practice manager. She's confronted by her, accused of being late despite having requested the accommodation and being approved to arrive slightly late that day. Complainant adamantly disputes that she was insubordinate, disrespectful. There was an altercation because complainant, as she testified in the Issues and Resolution Conference, stood up for herself and did essentially push back on the fact that she was being accused of being late when she wasn't. She had an approved accommodation to arrive slightly late that morning. Ultimately, She felt she was speaking up for herself, and she did feel this incident led to her termination just 2 days later on April 13th. Ultimately, though, we do feel that the reasonable cause finding is reasonable grounds finding is accurate and certainly reflects the record. There are certainly disputes of fact here, but we do believe those are best overseen by the administrative law judge at a public hearing. But thank you for your time today.
Commissioner questions for Attorney Gabriel? Commissioner David?
Kid, I'm a little, it went by me a little fast when you talked about the three counts. Is it the case that the first two are not there being considered for what reason?
So the two no reasonable
Right.
grounds findings are not contested. So the complainant
They're
did
not
not.
contested by complainant.
Right, so we're
normally you would
just,
just adopt them as written.
right, so
Okay.
we're really just focused on the reasonable grounds.
All right, so I was gonna ask her if she contested them, but she didn't
She did.
raise that in her answer.
There was no submission of disagreement by the complainant with the investigator's findings. There was only a submission of disagreement from the respondent as to the reasonable grounds finding.
And they, when they respond, they're that specific as to what they're responding to? I didn't notice that. Okay, thank you.
Yeah.
No questions for the attorney.
Okay, Attorney Parsons, hang on, you have a minute and a half.
Sorry, I can't do, am I to
You have
begin?
I was just messing with my timer to make sure I could get a minute and a half on there. Whenever you're ready, go ahead.
Okay, just to correct some things that complainants counsels just stated. There is absolutely zero record evidence of other employees being disciplined. So there is no record evidence that there are other employees who were disciplined and kept on board. Complainants counsel also omitted the evidence of the July 2022 warning about Ms. Marquardt's aggressive, rude behavior to a supervisor while she was trying to help her treating a patient, an insubordination that required the supervisor to have Ms. Marquardt leave her office. What the issue is here is that Ms. Marquardt was not terminated for attendance issues. That was part and parcel of a bigger problem. She was terminated based on her rude and aggressive behavior. She was terminated after many months of verbal counseling from the director of medicine at the hospital, a practicing veterinary of 60 years, who had recognized that Ms. Marquardt was not comfortable restraining animals. People didn't want to work with her because they were afraid they were going to get bit. And as Ms. Marquardt testified during herself in the IRC, she definitely has an attitude. She said she absolutely has an attitude and could have been aggressive with AP at times. So focusing on attendance is not the issue here. She was terminated after causing the verbal altercation with her manager in front of coworkers and patients. In addition, the record evidence is consistent and it's unclear why the investigator chose to discount.
That is your time.
Okay, thank you.
Commissioner questions for Attorney Parsons? Seeing none. Attorney Gabriel, you have 4 minutes and 14 seconds.
Certainly, thank you. And I will keep it brief. Just to directly respond, there is other evidence of employees being disciplined. I cannot say it's the only evidence given where we're at in the case. And certainly if the reasonable grounds finding stands, there will be other discovery efforts taken while the parties prepare for the public hearing. But there is other evidence. It was provided, at least one written warning was issued to another employee, Mr. Palmer, and it was related to cell phone usage. Ultimately, the allegation that people didn't want to work with Ms. Marquardt, there is dispute in the facts, and the testimony has, there's conflicting testimony here, and certainly At the Issues and Resolutions Conference, the employee relations witness who was provided by respondents confirmed that there were no other complaints or reports filed against complainant related to her employment. So there was nothing in her file that supported that there were all these reports against her or allegations against her. But ultimately, respondents claim there's many months of performance issues and conduct issues, but it's just not simply there in the record. There was no formal counseling. If there had been such a serious concern with her performance, the respondents had the ability to counsel and discipline formally. That was certainly something they had in their policies and their tool belt. But it wasn't the case that they did that here. And again, we dispute that she was verbally counseled to that level or at all. There was no prior counseling related to her attendance in particular. But again, we do feel that the reasonable grounds finding should stand here, and we appreciate everyone's time and consideration on this matter. Thank you.
Very much. Commissioner, questions for Attorney Gabriel? Okay, seeing none, we've heard from the parties, and then next hear from Investigator Brindley.
Morning, everyone. My name is Alex Brindley. I was the investigator assigned to today's case. I think most things have really been addressed, but I'm just going to run over my notes real fast. Yeah, so there was an issue about the text that Ms. Parsons brought up that was in fact an error on my behalf. A lot of the text messages that were provided, of which there were dozens, were not labeled to indicate who was who when texting. So that was my fault on that regard. However, even if we exclude that text, I still think my finding would be the same. And what I think is most telling in this case is that throughout their presentation here today and throughout their submissions, respondent has said that complainant was rude and disrespectful, late to work, had performance issues throughout the entirety of her employment with Midwest Vet Partners. However, it wasn't until she disclosed that she had started Suboxone treatment in March that respondent took any action against her. Her latest written warning that was previously discussed was in December of 2022 regarding the failure to complete tasks. Another individual was also disciplined for the same conduct, but was not further disciplined to my knowledge regarding that. But yeah, I think that's generally it. I'm open to any questions.
Commissioner, questions for Investigator Finley? Commissioner.
Alex, is there evidence about the side effects of the drug in terms of affecting behavior?
I'd have to look, but I think there is a doctor's note from complainant's physician.
I mean, it's said to be the reason for needing time off or being late or sleeping or that kind of thing.
That is, yeah, absolutely a side effect.
How about volatility or anything like that? Is that in there? No.
No.
Yeah, I just wanted to say that I found the report to be very helpful, and Alex, I appreciate your good work in this case. Thank you.
Thanks. Anything else?
Thank you, Alex. So we have 3 proposed findings, 2 no reasonable grounds and 1 reasonable grounds finding. If you would like to take them together or separately.
Yeah, I'll move that we take them all together and we adopt the findings of the investigator, no reasonable grounds with respect to the first recommendation, no reasonable grounds with respect to the second recommendation, and with respect to the one contested recommendation, as I understand it, in subparagraph 4, there are reasonable grounds to believe that MVP and Cape Veterinary Clinic discriminated against, complaint on the basis of disability, and conciliation should be attempted.
Second. Moved and seconded. Any discussion?
Yeah, I would just say, so you go ahead. I'm sorry. Because I'm on Zoom, I'm like trying to time my comments to jump in ahead of everybody. I would just say that, with respect to the contested claim, I mean, I think the lack of documentation is the thing that puts it over the edge. I mean, I understand where council's coming from, but it's an even chance standard, and I think there's an even chance that this claim gets over the hump. So
I agree. I just wanted to say, I learned a lot from this case. I didn't know that if you were actively in treatment, that was specifically provided for in the law. So thanks to the commission for teaching me.
All right. So it's been moved and seconded. We've had discussion. The motion is to adopt all three findings as written in the report. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay.
And we'll be in recess for a brief 5 to 10 minutes. Is that all right?
Let me just check and see, because I think that complainant is not here for the next case. And so
Oh,
we
really?
could just.
Oh,
dispose of
okay.
it.
You're right. All right. We'll call it then.
If the complainant is here, then yes, I would like a recess. If not, then we could.
Okay. Are you finished with your statement to them that?
Yes, we'll send a letter to the parties about the results of the hearing. They're gone, great. They're both familiar enough with this process that will not be a surprise. Is there anybody here for Ms. Crespo? See that the respondents are here. Do not see Ms. Crespo. Check my email. Gone through all of my emails today. I have not seen anything from her. Okay. In that case, when the complainant is not here, we generally adopt the findings of the investigator unless there are any questions for the investigator about this case. Okay. Then the report is, we have 4 no reasonable grounds findings. Do I have a motion?
I so move, we accept the recommendations from the investigator as reflected in the report with respect to all 4 no reasonable grounds recommendations.
Second.
Thank you. Moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yep.
Commissioner Douglas?
Yes.
Walker?
Yes.
Commissioner Sanders?
Yes.
All right. That concludes the hearing agenda for today. The commission will send a letter to the parties confirming the results of the hearing. Thank you both, Mr. Haig and Ms. Nichols, for being here.
It's not always this easy.
Yeah. You're muted, Mr. Haig or Mr. Haig. I'm sorry.
Thank you for your time today. Appreciate it.
Thank you for appearing.
Thanks for being here.
Appreciate respondents appearing.
As you may have heard earlier.
Thank you.
Sorry, I was muted. I just wanted to again thank the council and the investigator for their time and diligence in this matter.
All right. Thank you so much. Okay, so yes, we will be in recess for 5 minutes and then we will not go off record until we've had the vote to go into executive session, which I always forget, but we can go for a while. Yes. Hang on, you have to. We're back. It won't be in a second. Oh. Okay.
Then I will
answer whatever you'd like.
We are ready.
Pursuant to one MRSA 4056E, I move we go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second. Moved and seconded. Any discussion? Okay. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Sorry. Yes.
Commissioner Sanders?
Yes.
Okay. All right, everybody hold while we do some maneuvering. That's himself. I'll open the room and then you can assign yourself to me. Okay.
I don't know. I
SOM,
would assume
okay.
it's guest, but I.
Oh, and then we have to
What
join.
is this?
Okay.
State of Maine.
Okay. So I need a motion first to litigate H250206 and not to litigate E23-0339, E23-0366, and E23-0385. So moved. Second,
Second.
any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
And I need a motion to approve the agreements in MHRC versus Parsons and MHRC versus Nickel Antonio.
MHRC versus Hellas.
Sorry, versus Hellas. Parsons is a complainant. MHRC versus Hellas. So moved.
Second.
Moved and seconded. Any discussion? Right, yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Okay. I think that concludes our business. Thank you all. We'll see you in March.